All right. Welcome, everyone, to this deep dive into the world of customary international law.
Yeah.
And today...
Fascinating stuff.
I think this is going to be a really interesting one because we've all heard this term bandied about, over the years, customary international law.
Right.
But, I think when we actually kind of stop and think about it, it can be a little bit...
It's pretty slippery.
Flippery.
It is, yeah.
What is it exactly?
Sure.
And, why should we care?
Well, most people, when they think about international law, they probably think about, treaties.
Right. Treaties, agreements.
Big, agreements, conventions, all these sort of very formal legal documents.
And all the organizations that go along with them, right?
Exactly. And all of the institutions and organizations that go along with them.
Yeah.
But customary international law is something a little bit different, a little bit more organic. It's a little bit less black and white,
Less tangible.
A little bit less tangible, yeah. And it really revolves around this idea that there are certain norms of behavior among states that are so widely accepted and so consistently followed.
So it's like a habit, almost.
Yeah, you could almost think of it like a habit.
Yeah.
But a habit with some teeth.
Got it. Okay, so
because
a habit with legal implications.
Precisely.
Okay.
States start acting in a certain way.
Right.
They start doing things a certain way over and over and over again.
Right.
Other states see them doing it that way. They don't object.
They don't raise a fuss.
They don't raise a fuss. And then over time, this practice starts to crystallize into something that is understood to be legally binding.
Interesting. So like a precedent almost.
Yeah, kind of like a precedent, you could say.
Right.
In a domestic legal system.
Okay, but
in this case,
how do we know when we've crossed that line?
That's the $1,000,000 question.
Right. From habit, tradition to actual law. Exactly.
And that's where things get a little bit tricky.
Okay.
There's no sort of international court or tribunal that issues a ruling saying, okay, this practice is now officially customary international law.
Right.
It's a bit more...
That would be a lot easier, wouldn't it?
It would certainly make things a lot easier.
It would.
But it's a bit more of an interpretive process.
Okay.
And really what international lawyers and scholars and judges are looking for are two main elements.
Yeah.
The first is what's known as state practice.
Yeah.
And this essentially means that you have to have a significant number of states engaging in a particular practice over a significant period of time. Consistently, right? So it can't just be, one or two countries doing something. It has to be widespread.
Okay.
And it has to be, over a period of time that suggests that this is not just a fad or a trend. This is something that has become ingrained in the way states interact with each other.
Okay. So state practice. That's number one.
That's number one. The second element, and this is the one that I think really trips people up sometimes.
It's the one that trips me up because I was going to ask you.
Yeah.
How do you,
prove... What's the belief system?
Exactly. How do you prove what's going on in the minds of states?
Right.
And that's what's known as opinio juris.
Opinio juris.
Which is a fancy Latin term for the belief that a particular practice is legally required.
Okay, so you have to prove that they're not just doing it out of, habit or tradition, but that they actually believe that the law requires them to do this.
Precisely.
Okay, so how on earth do you go about proving that?
Well, that's where, as I said before, it becomes a bit of a detective game.
Okay.
International lawyers will look at a variety of sources.
They'll look at things like official statements by governments. Right. Pronouncements by heads of state or foreign ministers.
Right.
They'll look at diplomatic correspondence, legal opinions. They'll even look at the way states vote.
So their behavior.
At the UN or in other international organizations.
Okay.
And they'll try to piece together from all of these different bits of evidence whether there is a general consensus that a particular practice is not just something that states do because it's convenient or because it's polite.
It's not etiquette.
It's not etiquette. It's something that they do because they believe they are legally obligated to do it.
Wow. So it sounds like there's a lot of reading between the lines involved here.
There's a lot of interpretation. There's a lot of judgment involved.
A lot of gray area.
A lot of gray area, exactly.
So let's talk about, I know we're kind of getting into the weeds here a little bit, but I think this is really important to understand, because this does affect all of us, whether we realize it or not.
Absolutely.
So let's talk about some specific examples. Where does customary international law
Yeah.
actually play out in the real world?
Well, I mean, it's everywhere.
Okay.
It's one of those things that once you start looking for it, you start to see it everywhere.
Really?
I mean, a classic example is diplomatic immunity.
Right.
The idea that diplomats are not subject to the jurisdiction of the host country.
Right.
That's not something that is laid out in, a single comprehensive treaty.
It's just sort of understood.
It's something that has evolved over centuries of state practice.
Interesting.
Another example is the law of the sea, particularly the rules governing things like navigation and fishing rights.
So I always hear about, there's a certain boundary of water that's considered, international waters.
Right, exactly.
And then,
so the idea that coastal states have a certain amount of control over the waters off their coast,
right,
but that beyond a certain point,
it's a free-for-all.
Those waters are considered to be the high seas and are open to all states.
Okay.
That, again, is something that has developed largely through customary international law.
Fascinating. Okay, so...
And we can even think about...
I'm starting to see it everywhere now.
Yeah. We can even think about some of the prohibitions against the use of certain weapons in armed conflict.
Right.
Things like chemical weapons or biological weapons.
Right.
While there are treaties that ban those weapons, the prohibition itself is considered to be so fundamental.
So that's where those treaties came from.
That it's binding on all states, even those that haven't signed those treaties.
Wow. So it's kind of like, the customary international law informs the treaty.
Precisely.
In essence.
It often provides the foundation for the treaty law.
Okay, so this is really fascinating stuff, and I think, what's so interesting to me is that it's constantly evolving, right? I mean, we're seeing new technologies,
absolutely,
new global challenges. How does customary international law adapt to that?
Yeah, I mean that's one of the most interesting things about it is that it's not static.
Right.
It's not frozen in time.
Right.
It's constantly evolving to meet the needs of the international community. And so, as we face new challenges like climate change or cyber warfare or artificial intelligence, customary international law is going to have to adapt to address those challenges.
So how does that happen? Who decides, how it adapts?
Well, I mean, it's a bit of a messy process.
Right.
It's not, again, there's no sort of central authority that says, okay, here's how customary international law is going to change.
It just kind of happens?
It kind of happens organically.
Wow, so it's like the states themselves sort of drive that evolution.
It's driven by the practice of states.
Right.
It's driven by the way states interact with each other.
So as we wrap up here, I mean, what do you think are some of the, the big challenges facing customary international law today? I mean, are there any kind of, flashpoints or areas where we might see some tension?
Well, I think one of the big challenges is the increasing fragmentation of the international community.
Okay.
Back in the day during the Cold War, there was kind of a bipolar world.
Big sides.
It was the U.S. and the Soviet Union and their respective allies.
Okay.
But now things are a lot more complex.
Multipolar.
You have a lot more actors. You have a lot more regional powers.
Right.
You have non-state actors.
Yeah, companies even, right?
Multinational corporations.
Right.
And so it's becoming increasingly difficult to find that
consensus.
Yeah, that common ground.
That opinio juris.
Right. That's necessary for customary international law to really function effectively.
So almost like, herding cats almost.
Yeah, a little bit like herding cats.
Yeah. So as we think about this going forward, I mean, what are some of the things that listeners should keep in mind? I mean, when they're reading the news, when they're, thinking about these issues.
Well, I think the main thing is just to be aware of the fact that customary international law is out there.
Yeah.
It's operating.
It's shaping things.
Even if we don't see it, even if we don't always recognize it.
Right.
And it's shaping the way states behave. It's shaping the way the international system functions.
Wow. This has been so fascinating. And I think, as we end here, I just want to leave our listeners with a thought.
Yeah.
We've talked about all these different areas where customary international law plays out, but think about, the future.
Right.
What are some of the emerging issues that we haven't even talked about yet? Things like artificial intelligence, the governance of outer space, How is customary international law going to adapt to these new frontiers?
Absolutely.
It's something to think about.
Yeah, it's going to be very interesting to see how it all unfolds.
Absolutely. All right. Well, thank you so much for joining us for this deep dive
It's been a pleasure.
into customary international law.
My pleasure.
And we'll see you next time.
Sounds good.